Well, hello, everyone, and welcome back to Uncivil Law, where, as always, we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And I hope today is the day I earn that subscription. For this afternoon stream, we are going to be responding to a stream yesterday night from my good friend and yours, Nick Rekeita of Rekeita Law, who has responded in a little bit more detail or clarity regarding the Montegraph lawsuit and the issue of the SLAPP anti-SLAPP issue that I had raised and had questions about. I've listened to this once before, and I think that there's some good stuff in here for us to discuss, particularly as it relates to pleading standards versus proof standards, and some stuff we can learn along the way as it relates to some legal education. Of course, I want to begin, by noting that Nick Rekeita is my friend, and like him, as far as I'm concerned, there is no drama between us. I had a question, something seemed a little odd. I raised that question, and he responded to it in a way that at least partially, if not completely, satisfies it. But we'll get into the details as we go along, as we respond to this. So that'll be fun. So we're going to do that. So this is also, of course, I've also sent him a text message to say that I'm happy to talk to him. And perhaps unsurprisingly, he has not texted me back yet, even though I texted him like almost 12 hours ago at this point, but that's okay. He'll get to me eventually. All right. So this is from his stream last night. Of course, this portion of it was on Rumble. So we pick up his Rumble stream. This is at an hour 23:54 of his stream last night. Montegraph and his lawyer are insane. And I note in his coverage of this, I agree with Nick that many of Montegraph's proposed discovery requests seem quite odd, because many of the things seem like they would be things that Montegraph would know. And why would he ask Rekeita? Because they would go to his damages and to things that he would know. And why on God's earth is discovery going to apparently go on for a year? What do they have to discover? This is not complex litigation. Why do we need a year of discovery? Can't we do this in like a month? Apparently not, I guess. Because apparently they're talking about a year of discovery, which seems cuckoo for Cocoa Puffs insane. And I don't understand any of that, but I digress. All right, so we're going to pick this up where he's talking about this issue of the SLAPP, anti-SLAPP, and his view of SLAPP, anti-SLAPP, as it relates to this lawsuit. So let's pick up and see what he has to say.
Long story short, Kurt called out what he perceived as a hypocrisy on my part. So I have expressed in the past, and I stand by this expression, distaste for how anti-SLAPP laws exist in the world, in the United States specifically. Now, the context that I bring that up in has been in the past, California and Texas. I don't like anti-SLAPPs, really not a big fan. And here's why. Because lots of anti-SLAPP laws create an extra evidentiary burden on the part of the plaintiff to show something by clear and convincing evidence without a fact finder. They have this extra burden to produce proof that is beyond the initial pleading standards of a normal case. And I don't think that it's fair to put a burden onto a plaintiff to prove a case without having the benefit of a fact finder to determine the proof. It's a pre-trial trial. We saw this in the Vic case. And one of the big problems with it is how judges actually do this, because clear and convincing evidence is an evidentiary standard, and it's not that. It's clear and
he also searches for the right phrasing, because I always forget what it is exactly too, because Texas has this weird phrasing about it. So he has to look it up, which is fine, because I always have to look it up every time too.
Clear and
I can't even remember quite what it is right now, and I've already listened to this once.
Oh my God.
I can't quite remember what it is, which also goes to the confusion we'll talk about in a second.
It's not clear and convincing. think.
No, it's not. I know it's not. It's clear and
Mm,
particular, or clear and something like
it's
that.
not
Yeah.
clear. Hold on, let me find Texas.
Yeah. Yes, it's all right. I have to look it up too. I understand. No problem.
Clear and specific evidence.
Clear and specific. There we go.
Specific is the word.
All right,
because
yeah.
clear and convincing would be an actual higher evidentiary standard. Clear
Right.
and specific, they tend to state, is not a higher evidentiary standard, but they treat it as if it is. So what you have to do to overcome an anti-SLAPP in California and Texas is provide this level of evidence that is clear and specific to each element of the claim of defamation. That they made the statement, that the statement was made to a third party, that it was about the plaintiff, that it is the cause of the damages, and that it was made with the requisite degree of liability, either negligence or intentionality. Okay?
Right.
So you have to provide clear and specific evidence of that. Well, that can be kind of difficult in.
All right. So Nick is saying something about how this is done in practice versus how it's done in theory, and so he slightly muddles the issue, and it's not clear exactly what she's talking about, whether he opposes this in principle or he opposes this in theory. Okay, so clear and specific is not an evidentiary standard. It's a pleading standard. And it's very difficult, and it can be very easy to get them confused because it sounds a lot like clear and specific sounds a lot like clear and convincing. Those two sound very similar, right? Clear and convincing sounds very similar to clear and specific. Clear and convincing is an evidentiary standard. Clear and specific is a pleading standard. So they sound very similar, but they serve two completely different purposes. So it's not clear whether Nick opposes it in principle or opposes it in practice, because strictly speaking, it's not an evidentiary standard. And let me tell you what the difference is. All right. So generally speaking, in the United States, right, the difference in principle, let's just take it one level up, right? The difference in principle is how specific do I need to be on the initial complaint about what happened versus what do I need to show that it did happen, right? So a pleading is a mere allegation and shade, as Emily D. Baker likes to say, allegation and shade, right? Not necessarily any proof. It's allegation and shade. Proof is going to come in the issue of evidence that's going to come down the line, right? So there's a difference between the allegation and the proof. So when they're talking about clear and specific, they're talking about the pleading standard. How much allegation do you have to have? It has nothing technically to do with evidence. It has to do technically with how specific do you need to be about the thing that occurred. Now, normally in the United States, in both states and federal system, we use what's called general pleading or notice pleading. All right. Now, your mileage will vary slightly between different states and the federal system. So I'm going to speak generally for a moment, okay? So we'll all stay together, okay? I'm going to reduce this down to two different things. I'm going to get rid of all the nuance and put this into two different categories so that we can talk about this in a universal way that will apply nationwide, okay? So we're going to ignore the details and just put this in two categories to make our lives a little bit easier for the standard. Okay, so category number one, where most of your U.S. pleadings lie, whether it's state law or federal law, is what we call general pleading or notice pleading. All right, it's basically just putting you on notice, as the name suggests. All you need to do typically in a lawsuit is just give the other person notice, literally, about what you're suing them for. You don't need to give them details. You just need to give them enough to be able to understand what the hell you're talking about. Okay? So let's suppose, to make this simpler, all right, you and I got in a car wreck. Okay? I want to sue you because you hit my car. All right? Now, let's suppose I file a lawsuit and it says, you hit my car. This is not enough. Okay? This is not enough for a general notice pleading, because There's no information at all about this, right? You don't know what the hell we're talking about, right? Under what circumstances, where, who, what, when, where, why, right? I don't know anything I don't know anything about what's going on. I just know that there's an allegation that you hit my car. Like, what are we talking about? Are we talking about like you hit my car, like you smashed into my car with your car when you opened up the door? Are we talking about a vehicle accident? Are we talking about something that happened yesterday? Or are we talking about something that happened 5 years ago? Are we talking about a lot of damage? Are we talking a little bit of damage, right? So if all I say is you hit my car, this is not enough information. This is not enough information to put you on notice. It is not enough information to tell you about the basics of what happened. So some sort of notice pleading would look something like, okay, on August the 3rd of 2023 in the city of Austin, at the intersection of, 6th and Congress, you negligently hit your car with my car. That would be something that looks like notice pleading. Okay, it gives you the basic standards about what we're talking about, right? The who, what, when, where, why, right? It's just to give you the basic information. Where did it occur? Austin, Texas. When did it occur? On or about August 3rd. Where was it? On or about 6th or Congress. What happened? You negligently hit my car, right? So this is basic notice pleading, okay? And exactly the details you need is going to vary from place to place, but this is the kind of thing we're talking about. All right. Now, rarely in the United States, we have what's called specific pleading or detailed pleading, where you have to go into a lot of information. This is atypical. This is not used typically in the United States. The most obvious place it would apply is fraud. Fraud claims are specific pleading in the federal system. All right. So if I want to say fraud, if I want to say that you defrauded me, specific pleading. So it's not going to be enough for me to say that, you told me a lie and you cheated me out of, like, say, $10,000. I'm going to have to go into a lot more detail. I'm going to have to go into a much more specific detail. What happened? When did it happen? What is each instance of it? For each instance of the fraud, when, what, who, what, when, where, why, in more detail, more specificity, which accounts, which accounts, which statements, when, by whom, where, a lot more detail about the specificity of everything. You kind of have to spell everything out. You have to spell everything out with specificity. Another example where specific pleading is used is in a RICO case. This is mostly by operation of the federal courts hating civil RICO because they really don't want you to do it. So to prevent you from doing it, most federal courts will require you to do a specific pleading, right? It's not enough to say that there's a criminal enterprise. We're going to make you be like, really spell it out. Who, what, when, where, why in kind of somewhat excruciating detail to really put everything down in a very detailed way. All right. So it's the amount of detail you need to raise the allegation. It has nothing to do with the ultimate level of proof you need. It has nothing to do with the ultimate proof. It just has to do with how specific do you have to be in order to put the person on sufficient legal understanding of what's going on. All right. So hopefully that all makes sense. So basically what Nick is saying is he's saying it's an evidentiary standard, but he's wrong. It's not an evidentiary standard. It's a pleading standard. So when you talk about clear and specific or clear and particular or that kind of language, basically we're talking about moving from notice pleading, which is the typical standard. And what we want to do is be much more specific about our pleading. And this is why Vic Mignogna's lawsuit fell apart, because he didn't have this in the original complaint. He didn't have this in the first amended. He might have had it in the second amended, but the second amendment never got legally recognized because of how things were filed, right? So in the original filing, in the subsequent filing, it just said, okay, he was cheated out of, essentially, for example, business opportunities were taken from him because convention spots were taken away from him by people talking to convention hosts and preventing him from getting the spots that he wanted. But that's not enough detail in a specific pleading, which is exactly what the anti-SLAPP does in Texas. It says, okay, no, we're going to need you to be a lot more detailed. We're going to need you to say exactly who said what, to whom, when, on what date, in much more detailed information, clear and specific, right? So it's not an evidentiary standard. It's a pleading standard. It doesn't change the ultimate burden of proof. It just changed how clear you need to be about exactly what you said happened. The evidence that you'll bring to bear to prove that happened is completely separate from the pleading standard. So there is a technical difference. Now, it's unclear here whether Nick, because it's a little bit unclear in his language, whether he thinks that, whether he's confused about it, which, fair enough, it could be, or whether or not, because it is confusing. And if you're not keeping it straight, it can be something that you lose the plot for, particularly because they sound very similar. So it's not clear whether or not he understands this difference, which he might, or whether or not he's simply saying judges don't understand the difference, which is also a distinct possibility, because judges get lost in it. Because this is atypical, right? The normal standard we think about, and the normal standard judges deal with all the time, is general pleading or notice pleading. So that's what judges are used to. So when you start saying something else is required, they might in reality want a different evidentiary standard, which isn't technically what we're supposed to be doing. So it could be the judges are screwing up, which is a distinct possibility, right? It could be that the judges are demanding more proof in the complaint when it has nothing to do with proof, but rather just merely has to do with specificity. It merely has to do with how detailed you have to be rather than how much proof you have to bring to bear. So he is upset that Texas and California have this, but it's unclear to my mind, based on this, whether he is upset with it in principle. That is to say that he doesn't like the idea of specificity in pleading, and he thinks it just should be notice pleading. So it's unclear whether he opposes it in principle and thinks, no, this should just be notice pleading like anything else, or whether he opposes it in practice, which is to say, I have no problem with specificity as it relates to this thing. It's just that in reality, judges are not doing that, and they're actually putting in place a higher evidentiary standard, and they're screwing this up. So I don't like it because of what judges are really doing on the ground. In theory, good. In practice, not so good, right? So it's unclear. I suppose it could be both. He could oppose it in theory and oppose it in practice. He doesn't like the standard and he thinks he's screwing it up. But it's a little bit unclear which that is that he's talking about. Now, at least for me, I have no problem with it in principle, because although it is atypical to require specificity in pleading, as I mentioned, it's not unheard of. The most common example is fraud cases. Fraud cases require specificity in pleading. So it is not something completely unknown to US law. It's just atypical. It's just the abnormal experience. And is there anything wrong with requiring specificity in pleading? Well, the problem with it is that you may not have the information in the first instance. You may not have it. And as Nick is going to say in a second, it puts a freeze on discovery. So you may not be able to get to the specificity. So by requiring specificity in the front instance and dismissing it, you can never get there, which is also true in a fraud case, incidentally. Like, you may not be able to get there if you don't know the who, what, when, where, why with details and account numbers and all the rest of it, which to some degree in a fraud case, you might be able to track through electronic information. But it does require a lot more work on the front end. It requires a lot more work on the front end. And in some cases, you might not be able to get to it at all. So I don't really have a problem with it in principle, I think, because specificity in pleading is, especially when we're talking about the First Amendment domain, and we want people to have freedom of speech, and freedom of speech is good, that we should require more specificity so that we understand exactly what we're talking about, so that we aren't dicking around, wasting people's times on a First Amendment complaint that's not going to go anywhere. But that's sort of what's going on. Caroline says, is it an error to be specific in a general pleading? No, it is not. You can always be more specific than is required. Yeah, it is not error to be specific in a general pleading. You can be specific in a general pleading. It's not required. And different attorneys will be more specific to different degrees, depending on what they're trying to do, and also depending on their strategy. And also depending on another example where you'd be specific in a general pleading is if you want to try to accelerate things as the plaintiff, right? Now the problem is you're kind of putting all your cards up front, But the idea is, at least in principle, that by me doing that and putting everything up front, it's going to prevent us from dicking around in motion practice as much. Because, well, you can't be like, well, I don't know what's going on. So you understand exactly what's going on. So hopefully it will speed things up. It gives you more opportunities to attack me. It gives you more opportunities to make me look foolish if I don't have all my ducks in a row. But if I do have all my ducks in a row, if I've got it, then it prevents us from dicking around as much. So it is not error to be more specific in a general pleading, and different lawyers will be more specific to varying degrees of what they're trying to do. But what can be said for Ty Beard's initial filing in the Vic Mignogna case is it was very bare bones general pleading. It didn't really contain any information. For example, if you want an example where like you're somewhere in between, the recent indictment of Trump on the January 6th stuff would be an example where you're somewhere in between, right? That indictment went into a lot of information, which provided a lot of details. Not as many details as I would have liked, and we covered that, where there were a lot of problems in it, where it's somewhere in between. But you don't need that much information, probably. It's probably more than was required. But given the nature of the thing, the U.S. attorney wanted to provide more information than was required because they knew people like me were going to, tear it apart and wanted to try to circumvent some of that criticism. Unfortunately for me, I found the details to still be unavailing. So that's the problem. When you put your cards up front and you're like, well, there's still nothing here, then, you run into that problem. But if you have it, you have it. So that's all good stuff. It had 100 pages of exhibits. That's not specific. Well, as I went to in detail, as I talked about it for 3 hours on my stream, I had problems with it because it didn't really provide some information. It muddled the timeline. It muddled exact quotes. It kept referring to things without saying exactly what the words were in many cases. It screwed up the timeline by not providing exactly when they were said. And there were other problems with it. So was there a lot of details? Yes, but there left a lot to be desired. So it was somewhere in between. So yeah, there were questions in my mind. If you want a really good example, by the way, of something where like you didn't need as much information, but it was really, really, really detailed on exactly like who, what, when, where, why on all the dates. A really good example would be like Dominion's lawsuit, Dominion is the name of the voting company, right? Dominion Voting. Yeah. Dominion's lawsuit against like Fox News and like Rudy Giuliani and all that stuff. Dominion's lawsuit was incredibly detailed. It was very, very specific. And when I read that lawsuit, I was like, oh, because they really brought all the receipts. They put all the receipts in the original document. And I read the original and I'm like, oh, they're screwed. They're screwed because everything was there. So that was a good example where there was lots of specificity in pleading when Dominion did that. So hopefully that answers your questions to some degree. All right, so let's listen to a little bit more of this.
Some cases, specifically if you have to show evidence of that intentional aspect, knowledge of the falsity. And to have to get that before going to discovery can be a problem. So I don't like that extra burden. But that said, the other thing I've said about slap cases is that I feel like the rules of civil procedure already cover anti-slaps and should be implemented in a way that they allow you to still dismiss frivolous lawsuits. That's why the rules exist. I just don't think that we should create this extra burdensome step in an anti-slap. Now, that's my general stance. I stand by it. I don't like this extra burden. Colorado doesn't actually have that extra step. That's not how the Colorado anti-slap works. Colorado anti-slap comes out to merely a summary judgment motion with an automatic fee shifting. I think fee shifting should be done in general in the rules of civil procedure. If you bring a case that's bullshit, the fee should shift to you. I think that should just be how it goes.
I tend to agree with him on this point, right? If it's frivolous, if it's truly frivolous, you should have to pay fees. If there's no good faith basis to bring, like the normal rule in America is everyone pays their own way, right? Everyone pays their own way is the American rule. But I agree with Nick here that if a case is frivolous, if it's total bullshit, then you should have fee shifting because, you're putting a burden on the other side for their time, money, and expense. You're using litigation as a weapon where the process is the punishment. By having to go through this, by having to incur the expense and time and energy, the process is the punishment. So if it's bullshit, you should definitely be able to get fees. Now, under the federal rules, you should be able to do this under Rule 11 for sanctionable conduct. But Nick thinks that this should be a broader principle, which I have no particular problem with. This seems fine, right? I have no particular problem with the idea that if you bring a bullshit lawsuit, that you should have to pay the other side for their time and expense and energy because you're the one creating this nonsense nightmare. So I think that's fine. I agree with that much.
But that's kind of my general opinion. The Colorado statute doesn't have this higher burden of evidence or anything else. It's a summary judgment motion. So what you do on a summary judgment motion is just say.
So Nick's view of this, and I'll accept his view of what Colorado's anti-SLAPP is for the purpose of this, because I haven't looked into it, and I'm willing to defer to his understanding of what it is. Nick thinks that the anti-SLAPP in Colorado is just an anti-SLAPP with an automatic fee shifting. And if that's all that Colorado is, then fine. Then the tension is resolved. The tension is resolved, right, between what he thinks and what he's doing and the difference version. The tension is resolved because he is not behaving in a hypocritical way. He thinks that fee shifting should be generally a thing, and this is just summary judgment with fee shifting. So his view is completely philosophically consistent at that point. He again talks about this higher evidentiary standard, which strictly speaking isn't technically correct. It's a higher pleading standard, not a higher evidentiary standard. But again, I'm not sure if he's saying that because he's confused about the difference, or if he just feels like judges in general are confused about the difference, which is a very distinct possibility. I have no problem believing that there are a bunch of judges out there who don't really understand the difference between the pleading standard and the evidentiary standard. In fact, if you told me that there were judges out there that don't understand the difference between intent and motive in a criminal case, I'd believe you. So, not necessarily every member of the judiciary is necessarily as sharp as every other member of the judiciary. So, yeah, he may have a problem with how it is in practice versus how it is supposed to be in paper. So, fair enough.
For the purposes of this argument, we accept all the facts alleged as true. We do not believe that there is a legal remedy for recovery because defamatory statements are defamatory as a matter of law, or they're not. Right. They are either they might be protected opinion. They might be a privileged statement. Any of these things. That'd be the matter of law issue that is not for a fact finder. And so what you do is, in this case, you take all of the facts alleged. You say, okay, all of them are true. You still can't get recovery because this is protected speech. And that's what we did. And
yeah, so that's basically your motion to dismiss, motion for summary judgment either way, right? Motion to dismiss, motion for summary judgment. It's like there's no facts in dispute or none that matter. And I win anyway. That's what it's for, right? You have no legally cognizable claim, even assuming everything, assuming the best part of the party, right? Assuming everything you say is true, you still lose, and that's what he thinks. And fair enough. He has reason to believe that. I thought the judge's rationale, at least to my mind, made legal sense. I listened to Nick's explanation why he doesn't think it makes legal sense, and I think Nick has a sharp opinion. I think on balance, I might be more on the line of the judge than Nick, but that isn't to say that I don't think Nick is completely off base. It's just there's just some judgment calls that are being made along the way, as one does. And Nick thinks that this is straight opinion and context, and there's nothing actionable here and stuff. And it's like that is a reasonable opinion, even if mistaken. The judge thinks it's mistaken. The judge's opinion is reasonable, even if mistaken. And as I've said before, I'm not 100% sure there's anything a court of appeals could do about it. Although Nick thinks maybe it could be appealed, although I'm less sure. I'm not sure you could get a court of appeals to agree that the judge made a mistake that can be overturned in this context. So, okay.
I believe the judge decided that wrongly. But the judge essentially said that not all evidence is in the case, and therefore we're not going to make the summary judgment ruling. Now, again,
which is also fine too, because that would be one of the differences between summary judgment and the motion to dismiss, right? The motion to dismiss is there is no evidence that's possible. The summary judgment is there's been no evidence that has been discovered. Summary judgment is typically much more common at the end of discovery, right? Summary judgment is all about, well, we've had discovery now, and even given every fact they think that they can prove, they still can't win. So motion to dismiss is all about what could be, at least hypothetically. It's like even hypothetically you can't win. Summary judgment's more about what is, right? It's more about after you figured out what the evidence is. And so the judge thinks, at least hypothetically, that there could be evidence that could be discovered, even if it hasn't been discovered yet. Now, I don't know how that evidence could be discovered from Nick, which also goes to Nick's earlier complaint about the whole year-long discovery process, because all the information should be available to Montegraph, I would think. Like, what can Montegraph discover from Nick is unclear. Like, the videos that are defaming or not is information already available to Montegraph. The harm that has befallen Montegraph is something Montegraph knows, not Nick. So, like, what could Nick possibly give them at this point is unclear. But okay.
And I think the judge is incorrect on that, but that's how it goes. The only option would be to appeal or to move on. So those are the two options sitting at the fork in the road. That being said, I don't think that's inconsistent with anything I've ever said about anti-slaps.
I don't think so either. I mean, I obviously have not heard Nick speak in his view about slap or anti-slap with any specificity before. I just knew vaguely that he had problems with it, and I raised the question, is there a problem here? And so, I don't perceive that there's any conflict about it. He even if he and I disagree about the merits of anti-slap in principle, he still wouldn't be a hypocrite, because at that point he's not taking advantage of something he doesn't believe in, right? So even if we discussed it and we disagreed about the merits of anti-slap, which I think is a strong possibility that we disagree, right? We might disagree about, for example, Texas's version of anti-slap. I can see us having a discussion and us getting to the end of that discussion, and I say, you know what? I think Texas's anti-slap is a good thing. And Nick says, I think Texas's version of anti-slap is a bad thing, right? But regardless of whether he thinks it's good or bad, it doesn't make him a hypocrite, because we're not talking about Texas's version or anything that's like Texas's version, according to Nick's understanding, because Nick's problem with Texas's version is either in principle, it's applying a different pleading standard, or in practice, judges don't understand what a pleading standard is, and they're changing the evidentiary standard. Either way, it's putting a burden that's unfair on the plaintiff that the plaintiff might not have the ability to fix, because they can't get to discovery, because at least in Texas, they freeze discovery. So how can you get to the level of specificity you need without discovery? Now, at least in some cases, you can do that, I think. But Nick's broad point that even if you could, like, I think, for example, in the Vic Mignogna case, that Vic and his lawyers could have gotten enough without discovery to plead this case, because you don't need formal discovery. Formal discovery is nice, but you can do it in an informal way. Like, you could contact the conventions, you could contact people get statements, get sworn declarations, get emails. You could do things. You can do discovery without discovery, right? Discovery is just a formalized legal process, but you can do it if people are cooperating, or at least try, and you might be able to get some of this information as well. Matt says, are you saying you never use a legal rule that you don't think should be there in the first place? You'd rather go to the jail than use an unjust rule? Um, that's a very strange question and somewhat off point. I don't know the answer to this question. I don't know. The question is somewhat hypothetical. I would say that, if I personally don't believe in something, I don't think that I should take advantage of it merely because it's convenient for me. Because then I'm not because then I don't really then I'm not really then I don't really believe in my own principles. So I think you should be principled. So if you really believe that a legal rule is unjust, then taking advantage of that legal rule merely because it will benefit you in the moment undermines your statement that you believe in it. It is hypocrisy. It is hypocrisy, right? Because you're taking advantage of something you don't think is just. So by your own morality, by your own morality, you are doing something that you believe is unjust merely for your own convenience. And so, you know, probably if you believe it's fundamentally unjust, I guess. Yes, would be violating the rule lawyer's duty to fight aggressively for his client. No, it wouldn't, because in this hypothetical, we're talking about myself, not me representing somebody. The question was, should I take advantage of a rule? Or should Nick take advantage of a rule that benefits himself? This has nothing to do with the lawyer's duty to his client. This has to do with your belief in this thing to yourself. So, yeah. I think so. I think so. I personally would use an unjust rule in my defense, even if I disagree with it. If you're at a fixed table, why not cheat? Well, just because everyone else is a liar doesn't mean that you should lie, I suppose, is one way to put it. Just because everyone else is a cheater doesn't mean it's okay for you to cheat. Right? I don't. Right? You either believe in things or you don't. Right? You either believe in things or you don't. Like your argument is one of pragmatism, which I suppose is a kind of morality. But my argument is not based in pragmatism. My argument is based in more of a fundamental ethics. Like it's more based in a not what will be efficient, but what is fundamentally good. Right? I mean, it is not just because everyone else is speeding doesn't mean that you should speed, I suppose, is one way to put it. Right? Just because everyone else is doing a wrong thing doesn't make it okay for you to do a wrong thing. Just because everyone else is living in Sodom and Gomorrah doesn't mean that you should reduce yourself to the baser instincts. So I don't know what to tell you beyond that. I agree with Matt. It's not hypocritical to use a rule you disagree with unless you suddenly like the rule when you use it. I don't know. There's something. Maybe hypocrisy is not the right word. This is not a law argument. Who said it was? Who said it was? At what point did I ever say that what Nick was doing was illegal? At what point did I ever say that it was a legal problem? My whole point was hypocrisy in the first place. You do realize I can comment about things beyond law, right? So saying it's not a law argument is somewhat defeating the point. You're right. It's not a law argument. You're correct. I'm making an argument outside law. Wow. Deep. Your brilliance is beyond all compare.
I do not like this idea that a plaintiff has an extra evidentiary burden in some states to quote unquote prove their case without the benefit of discovery, because once you file an anti-SLAPP in California and Texas, in most places, discovery is stopped. And that's kind of a problem if you need some of this evidence, right? Like to prove their state of mind. But hey, I don't know. This is why Minnesota got rid of its anti-slap.
Mr. Armageddon says, I disagree with you, Kurt. It's only hypocrisy if you think the rule is good when you use it. He can still say this is a bogus legal rule, but I'm going to use it because it's there. So you can use it while acknowledging that it's bad. I'm not sure that makes sense. I'm not sure that makes sense. Unless you're trying to like overcome a greater evil, I suppose. So if your argument is I'm doing evil to overcome a greater evil, then okay, but maybe, but to use a rule to benefit you is to some degree say it's good. Is to some, you know. I don't know. I don't know. $5. Everyone's a hypocrite. It's a debate of hypocrisy. Come on, you're a lawyer. Do you buy Chinese goods if you buy American? What? Tax law you disagree with? I don't know of any tax law that I disagree with that I've taken advantage of. But okay. There's something very unsettling. I mean, if we're going to the underlying ethics point, you know, I think that there's something very unsettling about saying this is bad, but I'm going to use it for my advantage because it's there. How does that not like, am I the only one that sees this as a problem? There's like, this is a bad thing. This is a wicked thing, but I'm going to use it because it's there and it benefits me. Who said it was a crime? Why are we talking about crime? Do people understand that I'm able to talk about things beyond the law? What are we talking about? I don't like you people very much. A man illegally assaults you with a weapon. You don't take it from him and defend yourself? Of course I do. But I have a right of self-defense. What are you talking about? This doesn't make any sense. His illegal action. What are you talking about? This doesn't make any sense. He is illegally assaulting me. Me taking the weapon from him and defending myself is behaving lawfully and justly. It's moral. It's both legal and moral. His actions are illegal and immoral. My actions are legal and moral. There's no hypocrisy in that. Him attacking me is both illegal and immoral. Me taking his weapon away from him and using it to defend myself is both legal and moral. Because self-defense is a moral right. I have the right to defend myself. It's a moral right. What are you talking about? The weapons would be legal to possess. Well, even in that circumstances, the self-defense would still be legal. And there have been cases like that, incidentally. The self-defense would still be legal. The weapons possession might not be, but the self-defense would be. So I've actually seen cases like that, incidentally, legally. It has occasionally happened, although obviously rarely, where you'll have a felon in possession who uses it in self-defense. You can do that. The self-defense is legal. The felon in possession is not. Right? Because the underlying act of defending yourself is lawful. So you get away, you plead justice, so you get your justification for the homicide, but you get the weapons charge. Now, that has occasionally happened in law. It has occasionally happened. What about a duty to retreat state? Even in a duty to retreat state, even in a duty to retreat state, the duty to retreat only applies if I can retreat in complete safety, which incidentally is a good idea in any event, to be quite honest. If you can retreat in complete safety, you probably should. This is for practical reasons, and also for your own health. Okay? So my advice is, regardless of where you can live, if you can retreat in complete safety, you probably should. Because if you choose to engage, when you don't have to, because the premise is you can retreat in complete safety. So that's the premise. If you choose to engage, there's a chance you might lose and die, which is bad. But if you can retreat in complete safety, then you can retreat in complete safety, which means there's no chance you can die. That's superior. So my recommendation would be, if you can retreat in complete safety, you probably should do it. $5 from Nuvi says, Rackets invited you on to discuss this. He did. He invited me on at 10:35 p.m. I was already asleep. How about you invite him on now and discuss this? I sent him a text message. "11 and a half hours ago, I sent him a text message. He has not responded to my request. So we're discussing it now. Thank you for your comment. He gave me 35 minutes. I gave him 11 and a half hours. I want to talk about it now.
By the way. But the interesting thing is Minnesota's procedure on dismissal and summary judgment is the same as the Colorado anti-SLAPP. Again, that one's just a fee-shifting burden. So all we asked the judge to do was say, yeah, all this stuff is true. I mean, what am I going to do? Deny I said stuff that was recorded? All the statements alleged are in videos that are still public. So I'm not sure what factual dispute there is.
Nick is never going to text me back. Nick is never going to text me back. The man cannot respond to a text message or a phone call or an email to save his life. I love you, Nick. I love you, but you have a reputation in this man's eyes for being somewhat poor at responding to your emails, texts, phone calls, or any other method of me trying to get in touch with you. The man is not good about responding to the text messages. So I gave up hope after 11 and a half hours because, yeah, he's never going to respond to my message. Because he never responds to any messages. Because the man doesn't believe in, following through or responding to things or trying to put together plans.
We disagree as a matter of law that the statements are defamatory. So that's my statement about it. But I don't know. I'm not mad at Kurt for coming to that conclusion. I don't think Kurt has watched every minute of video I've ever done, so he might not have seen my explanation of anti-SLAPP in this case versus the other.
I have not. No, I have not seen everything you ever did. And if you go watch my original video, I made it quite clear. I'm like, I don't know if I'm speaking out of turn, or I don't know if I'm quite getting this right, or it's like, I'm not quite sure if I'm confused. So I didn't even purport to pretend that I knew everything about his position. I'm just like, hey, didn't he speak against anti-SLAPP once? And how's that compatible with this? And I just raised the question because I'm like, And then I had an argument with chat forever, as we've been having an argument with you guys about whether or not it's okay to use something that you know is wrong because it benefits you, which makes me wonder the degree to which you really believe it's wrong. I'm not, it's like that you believe it's wrong fundamentally. It's like you believe it's wrong, but you're going to do it because it's convenient. I don't know if that's the hypocrisy. It sounds like hypocrisy. That isn't what he's doing here because he's made his position clear. But, I don't know. You come up with a better word for it than hypocrisy. Okay, you come up with a better word for it. All right. What is it called when you use something that you believe is bad, but it benefits you? What is that called? I guess we could call it pragmatism if you guys like.
And I still think that there shouldn't be a need for anti-SLAPPs at all. We have motions to dismiss. We have motions for summary judgment for these reasons. They already exist in the world. And like I said, in our case, the only outstanding piece of evidence for the purposes of the summary judgment motion, to rule in our favor anyway, are the damages that he should know because he's alleged them. So by withholding their damages, now it's on us to discover what they have to disclose.
Yeah, I agree with Nick. That's some bullshit. The monograph is coming after him for discovery for things that I don't know why Nick would have those things is a little bit beyond me. This discovery thing, I don't know why they agreed to this discovery schedule because this is apparently a joint motion. Who decided for a year of discovery? Who decided this? I guess he and his attorney. Why? Why did they agree to that? What are they going to be doing for a year? You know? Who does this?
I guess. So I don't know. But, I don't challenge the fact that I said these things at the time alleged. The question is, have they brought a sufficient case to survive summary judgment? I don't think they have.
It's a fair opinion.
But that's not a balance of evidence question. Has nothing to do with the actual occurrence of discovery. They had a chance to bring all the facts, and we agree to the facts and say, rule. Judge chose not to at this time. So anyway, I just wanted to put that drama to bed. I was hoping to talk to Kurt about it because I said, I think all of Kurt's quote unquote criticisms, if that's what they are certainly done in good faith. I don't think Kurt does anything in bad faith, at least towards me.
I try not to, my friend.
So
I try not to.
I don't know.
I try not to do anything in bad faith. I always try to be as honest and fair as I know how to be. You guys hopefully know that by now, that I always try to be honest and fair as I know how to be. And regardless of who it is or what's going on, tries to try to be the best legal mind that one uncivil knows how to be. And always try to be fair. So that's what he had to say about the issue. So it satisfies the hypocrisy issue. It satisfies the hypocrisy. That's the too long didn't watch for all you guys. Okay? That's the too long didn't watch. It satisfies the hypocrisy issue. Nick has given a satisfactory answer. He has distinguished the Colorado statute in a way that makes logical sense. And he's distinguished it in a way that solves the problem. So Nick is like, he did exactly what he needed to do. Like he says, I don't like the Texas statute and the California statute for this reason. Colorado's version doesn't have that problem. Therefore, Colorado's version is fine. Also, I think that this should just be a general rule that kind of exists outside of anti-SLAPP and a more general rule anyway. And so therefore he's not even a hypocrite anymore. So it solves the problem. It solves the problem. He's not a hypocrite. He has a completely consistent worldview. So it solves the problem. So this entire discussion I've had with the chat for like 40 minutes where we've been arguing over the finer points of whether it is hypocrisy or not is now kind of rendered moot. Because because would this be hypocrisy or not? This entire like 40 minutes I've had arguing with chat is now rendered moot because, well, he's not being a hypocrite, so it doesn't really matter anymore. So, yeah. Am I just saying that? Why would I just say that? Why would I just say that? That doesn't... Jay the J-Lizer says that you're just saying that. No, first of all, I'm not just saying it. I explained it. I explained if you were paying attention. Also, why would I just say it? That doesn't make any sense. Why would I say what I said in the first place? That, I think there's a problem, and then just say something different. Why wouldn't I just maintain the position? Why wouldn't I just say, no, Nick is completely wrong? What is this hypothetical? Why would I do this? What are my motives to just say this? I don't... Ugh. Thank you, Jennifer, for the chat. Yeah. Nick has narcolepsy. Yeah, I know he has some sort of sleep condition, so that makes sense for sure. Yeah. Why would I say something I don't mean? What's the point? So it's all, I guess people didn't want me to say it because they want there to be this massive conflict between me and Nick, which there never was in the first place. They want me to be like, no, this doesn't solve the problem. And Nick is still a hypocrite, but that's not what I think. So sorry for there to be an end for the drama, people, but you know, there's no problem here. Do I have any plans on meeting Asi Overlord? Yeah, certainly. If he's at Anime Matsuri, I will. Sure. Yeah, if he's anywhere near me, I'd be happy to meet him, and I'll be happy to meet him at Anime Matsuri. I assume that's why he's here. So I'll see him next week at Anime Matsuri. Should meet up with Aussie. I'll be happy to meet with Aussie. Is he near Austin? I assume he's near Houston right now, which is a little out of my way. He's in Houston now? Okay. Well, that's 3 hours from my house. So next week. I'll see him next week. Okay. Yeah. Next week will be fine. Yeah, it's a 3 hour drive from my house. It's not exactly around the neighborhood. David Wellman says, "Love you, brother. How about them gains?" Word. He's already in the U.S. You need to go to the hat place with him. We can meet up in the middle. Texas is not a small state. That's true. I remember when I first entered Texas, and you see the mile marker sign because the mile markers count down when you're going from east to west. They count down from east to west. And the mile marker when I first entered Texas was something like 600 or something. And that's a big ass number. It's a big ass number. When you first enter Texas, and the first mile marker you see is like 600. And it's like, well, this is going to be a hot minute, you know? Miami is 3 hours away from Miami. I at the right time of day, I believe that. Yeah, that's certainly possible. Nick is a good guy. Nick is a good guy. I like him personally. I like his personality. I like his style. I find him to be a honest and honorable person. I find him to be a thoughtful person. He's good to his friends. He has a jovial demeanor. He is uh, at least more superficially resilient than me, which I value. He is he's good to his wife, loyal to his kids. He's a good father. He's a good guy. Oh yeah, I didn't assume that his failure to respond was him not caring about his friends. He just has a bad habit. He has a flaw. He has a Persian flaw as a man. He has a character flaw. And his character flaw is he's really bad at responding to text messages or emails or phone calls. So I suppose as far as character traits, as far as character flaws go, it's not too bad. Could be worse, but it's definitely a flaw of his. That's okay, Mandy. If you can't super chat, I appreciate everyone who can. He's never there for his chat either. That's pretty funny. I think I missed some super chats from earlier today. No, think I read these. Yeah, Rose hit the smash button. Dude, what the fuck? He didn't say anything bad about you. I know. I know he didn't say anything bad about me. What are you talking about? Oh, you mean because I'm being a little bit critical about him about the text message thing? Oh, dude, man. He's come on. I mean, all right. I mean, I'm just razzing him a little bit. I'm razzing him a little bit. Because he's my friend. I think it's okay. I'm just razzing him a little bit. I was so confused when he said, "Oh, he's saying something bad about you." What do you mean? What did I say bad about him? I'm just razzing him a little bit because he's my friend. It's a joke. It's a joke. You know, it's just a little joke that I'm like, hey, it's just, he has this problem. Just just to razz him a little bit. I think he would get it. I think it's okay. Yeah. It's just a little razz. Did I make commentary on the YNW Melly case? I did a video for it for Attorneys React. You can check it out. Kurt says, when you talk really, really fast, I can see your wheels turning. I may differ at the end, but I like seeing how your brain works. So much more pretty than everyone else's. Plus the funniest in cooking. Thank you. Yeah. Nuvi says, if Nix doesn't answer texts is saying something bad. The way my friends and I talk to each other probably make the guy cry. Yeah, for sure. I'm in an apartment. I'm going to talk about the Lizzo lawsuit. Lizzo's in some trouble, man. Some of those allegations are intense, man. Woof. We went to the red light district. She made us catch dildos that were fired out of another woman's vagina, which incidentally, I mean, I've heard of like the ping pong ball trick, but I didn't know you could fire full on dildos. Because I mean, those have some mass, don't they? What kind of muscles do you need to fire a dildo out of your vagina? How do you get that trick done? I have questions that I don't want answered. Please don't anyone ever tell me. I don't want to know. That one will just have to remain a mystery to me. And apparently also that Lizzo's dancers were forced to eat bananas that were protruding from other women's vaginas or something. Yeah. So there's a lot of stuff there. There's a lot of stuff there. Riviton says to use the rules to say it's good is simply a false premise, and you haven't demonstrated it. You seem to owe an explanation for something that's intuitively false. Well, I would disagree it's intuitively false, but if you're using a rule and you don't have to use the rule, if using the rule is optional, okay, if using the rule is optional, so we'll take away the situation from which you're forced to use the rule. If using the rule is optional, then to use the rule is to say that it's good on some level, because you're at a bare minimum saying that the rule is good for the purposes for the rule. It's like it is good for its own purpose. And there also does seem to be a moral dimension to it, right? I mean, if you don't have to invoke the rule, but you do invoke the rule, and you're doing it for your own benefit, then doesn't that seem to suggest that the rule is good, or that you think the rule is good? Or at least you're willing to ignore the issue because of the pragmatic benefit. But I'm not sure that you can use a completely optional rule. This whole thing, I mean, I assume that I guess you could think that you have no opinion on it. This only works, this only matters in the situation where you think the rule is bad, right? So like, this only matters in the situation where you think the rule is bad because you're using a rule for your own benefit that you yourself think it's bad. And so there's tension. So I don't think that it's a false premise. Maybe I'm not adequately explaining it, or maybe my thoughts are muddled, but I think there's something there somewhere that makes some sense. Chartreuse Fraud says, can you be a hypocrite if you have no principles? Probably not, right? If you don't, if your only principle is whatever benefits me, which I suppose is a principle, which presumably, you would want to benefit you. So if your only rule is whatever is pragmatically to my benefit, then you're only a hypocrite if you're only a hypocrite if you don't let other people do that, I suppose. Is it a rule if it's optional? Sure. Rules can be optional. Many rules are optional. Yeah, rules can be optional. Yeah. Many rules are optional. There are rules that are optional all the time. What if you use a rule that you think is bad and a system you think is completely screwed up? You might not have the reasonable option to participate. Well, this is all dependent on you having the option, right? This is all based on you having the option. This is all about your ability to choose to invoke the rule or not. So if you don't have the choice, this all falls apart, right? If you're forced into it, then this all falls apart. This only works if you have the choice. Then I suppose that in your hypothetical that it could be the least bad choice. I suppose there's that. So maybe the question you're really asking me is, what if you're in a situation in which there are no good choices? Then what do you do? Because all the options are immoral or wrong. So I suppose in that scenario that you pick the least wrong rule, or the rule that causes the least total harm, if that's your question. So, but yeah, so you would pick the option that is the least bad, I would think. But I'm not sure that focusing on immediate pragmatic benefit is, a lot of people do things for immediate pragmatic benefit. There are a lot of people can justify a lot of things to themselves on immediate pragmatic benefit. I'm not sure that's necessarily a good rule for morality. That's just a good rule for what benefits me, though. The real rule is whatever benefits me, regardless of what I said. Tax code exemptions. You can use some exemptions. If you disagree there should be exemptions, are you hypocritical? Maybe. That's a good. I suppose it would depend on why you thought it shouldn't be a rule. Like if it was fundamentally like a moral issue, maybe. Yeah. So, yeah. It reminds me of that old like Twilight Zone episode. It reminds me of that old Twilight Zone episode where the salesman comes to the door and they give him a button and says, if you push this button, you will get $1 million, and someone you don't know and never met will die. Right? So that's the whole thing, right? It's like that's the whole thing of the episode, right? Well, won't they push the button? So they give it to the salesman gives this button. If you push this button, you will get $1 million, and someone you have never met will die. And so, they talk amongst themselves, and they talk about how they can use the money, and how, people die all the time and all the rest of it, right? And they struggle, they struggle, they struggle. And at the end of the episode, they decide to push the button. And the salesman comes to the door and says, "I want the button back." And he says, "Here's $1 million." And they say, "Well, what will you do with it?" He says, "Don't worry, I'll give it to someone you've never met." Yeah. Yeah. So, so the Milgram experiment, yeah, things like that. Yeah, for sure. An immoral thing does not become moral merely because it benefits me, right? And an immoral thing does not become moral merely because that's kind of like definition 101 of sin. Like, if you want to, my Rubik's cube is blinking in the back. Sorry about that. I'll have to fix that later. Um, I'm not sure why it's blinking in the back, but my Rubik's cube is blinking in the back. I'll fix it. Maybe it's low power. It's sad. I'll fix it later. So you'll have to deal with my blinking Rubik's cube. But yeah, you can justify a lot of immoral actions for pragmatism, but there's a problem there. I have gigabit internet with AT&T Rash, so I don't know what to tell you about freezing up or not. I have gigabit internet with AT&T, so I'm supposed to have really good internet stuff. So if I keep freezing up, I don't know what to do. Why would a Rubik's cube blink? Because it's a special Rubik's cube. It's a Bluetooth Rubik's cube with lighting and stuff. It's a special Rubik's cube. It's super advanced Rubik's cube. It's a Bluetooth powered Rubik's cube that will talk to your phone, and your phone can know where it is and stuff. Am I familiar with Uvalde law firm out of Dallas? No, not so much. You consider it morals? Who decides morals? Well, in this particular scenario, you do. Right? This is all within your own framework, I suppose. This is all within your own framework. So for the moment, we can just make it that you decide what morals do. But I don't think merely putting aside because convenience, though, makes it work. You want to see the Rubik's Cube? Okay, hold on. Fancy Rubik's Cube. See? And it's all ball bearings too, so it's really easy to scramble and stuff like that. What's my best Rubik's Cube solve time? I can't solve a Rubik's Cube. I can't solve a Rubik's Cube. I keep trying to learn, but I can't do it. So my best solve time is infinite. Let's see if I where my Go Cube. Okay, hold on. Okay. See, it blinks when it's talked. So see how it's lit up? See how it blinks? Hold it so the green center is following me. Okay. And the logo is facing up. Okay. So hold it like this. Continue. Okay. Let's see. Solved. Solved. The computer teaches me how to solve it. So I can't solve it, but the computer can. You want to see it again? This is the Go cube, by the way, if you want to get one yourself. The Go cube. All right. Solve. Go. Sit down. Solved. So yeah, it's a Bluetooth Rubik's cube. There you go. All right. So it's a smart cube. It talks to the phone and tells you exactly what position it's in. So yeah, it'll teach you how to solve Rubik's cubes and stuff like that, and it'll teach you classes, and you can do challenges, and you can do all kinds of stuff. All right. I'm going to sign off for now, and hopefully we'll talk to Nick some point today. We'll see. Give some super chats. Rob Price is a member for 16 months. Rabbit is a member for 4 months. Rabbit gifted 20 gift memberships. Thank you very much. Emily Mullins gifted $9.99. Dana Crouch $5. Thank you very much. And thank you, Emily Mullins, for your first super chat ever. Scorpion 142 says, I don't think this rises to the level of good or evil, but maybe right or wrong. It's certainly permissible. Mads gave DKK 50. Hope I didn't derail the conversation too much. Now we're fine. Nuvi gave $5. Jennifer gifted 20 gift memberships. Dave Wellman, love you, brother. How about them gains? Nuvi gave $5 saying Kurt has never just said anything. He always tells us what he thinks, even if we hate it. True that. 10 minutes behind, but today's life lesson from Kurt: dying is bad. Chance to die, less bad. Living is best. The more you know. Robert Allen Jr. is a member for 7 months. Crypt Keeper VT gave $5. Ask Yeskiza gave $5. Mr. Armageddon gave $20 to say, I agreed with your entire take today. I understand your hypocrite opinion, which, by the way, has now been revised. I guess it comes from me, Kurt, that Nick never said someone shouldn't use the Texas anti-slap law. Robert Price is a member for 16-month. Rabbit. Yeah, okay, so this is just cycling back. Bo Beats gave 2 CA. Love your smile. Alana gifted a 5-pound thing, and Mr. Armageddon gifted 20 CA. No signing off? I'm signing off. I was reading super chats. What do you want? Oh, you don't want me to sign off. Okay, what else you want? What else you guys want to talk about? I had a nice meeting today with this potential new acting school I'm going to do. So that was fun. The lady who ran it seemed nice. We had a very interesting conversation. And it was fun. So that looks good. And then, of course, so she said that, sometimes availability can be a little bit difficult, but she'll let me know by the end of the day whether or not they'll have a slot for me. But I think she's going to say yes. So I'm kind of excited by that. I'm still signed up for the stand-up class, I think at the end of the month. They haven't sent me... Did they send me a confirmation on that or an email, or what did they send me? She said I can come next week. See you at 10 a.m. So on Thursdays, that's 10 a.m. So that means that Thursdays, I guess we'll have to do something different when it comes to streaming, because this acting class is in the middle of the day. So not so much so she just gave me a confirmation that says I can come. So I'm excited about that. So not so much with Thursday streaming anymore, because I'm going to be doing this class. So maybe we'll do something in the afternoons or evening, late night stream instead, but it won't be a morning stream on Thursdays because I'll be busy. Uncivil, you'll be at Matsuri next week. Well, not Thursday morning. I won't. So yeah, I'll do the class at 10. I'll do it for like 2 hours, and then I'll drive out to Houston in the afternoon, which is fine. So I'll see you guys Thursday afternoon in Anime Matsuri. You guys will miss me for half a day. You'll live. Timing seems tight. No, it'll be fine. It'll be fine. And if I don't see you Thursday, I'll see you Friday. It'll be okay, guys. I promise. The acting class is going to take priority over Matsuri. So if I do this class from 10 to like 12:30 or whatever it is, if I don't leave there till 1 and I'm not in Houston till 4, so if I don't see you on Matsuri on Thursday, well, you guys will be okay. It'll be fine. You guys will have to be without my shining presence for one more day. I know it's disappointing for you, but that's where we are. To ever do a mock trial with other law nerds, what role would I want to be? Whatever was like the most difficult role. I like to try to work. Yeah. EDB can be prosecutor. I'll be defense attorney or something like that. She'll make me work for it. It'll be fun. When is the stand-up class that I'm supposed to be taking? Trying to find a receipt or something. Hold on. Too many thoughts going through my head at once. Merlin works. No, that's not it. What is the other one? Merlin Works has storytelling classes. I need to look into that too. That looks good. August 30th. All right. So, all right. So that's August 30th. And the storytelling classes. What do they have? Storytelling 101. Ooh, one to do like Moth Radio Hour Story Slam. That sounds fun. August 15th. I might have to sign up for that too. Too many things going on in life at once. Too many classes. Is Aussie here? Hello, Austin. Hello, Hayden. I hope you're enjoying being in Texas. Yeah, I'll see you, Aussie. I'll see you Thursday afternoon. So, just text me or DM me or something. And I'll be happy to see you. Yeah, there's a big deal presenting for the Moth. It can be, for sure. Yeah, I might sign up for that class too. I'm gonna have to drop improv or something, I think. You're live in a half hour? Excellent. I'll send you a redirect, Aussie. I wish YouTube made it easier to do redirects. Aussie, do you have redirects set up? Uh um Do you have the live already set up? Life in the US Day 2 recap. He doesn't seem to have redirects set up for me. He doesn't seem to appear in my redirects. Oh, there he is. Okay, there he is. I'm not sure why he wasn't showing up at first. Okay, great. All right. YouTube doesn't necessarily make it as easy as, for example, Twitch to do redirects. It's a bit of the pain in the ass, but they're set up now. Drop improv. Improv has been great for me. Yeah, improv has been great for me, but I'm trying to branch out into other things. While before I move to Houston, and I'm interested in doing some of these other classes. I did improv before I moved to Austin. I did improv as well in DC. I did 9 levels of improv in DC, and so like I have some improv experience. So I might have to drop improv, or I'm going to have to do a different school on a different day because I'm just having these time commitment issues. So it's been fun. It's been good, but I'm interested in some of these other classes like storytelling and stand-up comedy and stuff like that. And this acting class. And, I can only be in so many places at once. I haven't been over to the mothership yet. No. Thank you for saying I handle hecklers better. That's nice. I appreciate that. And yeah, I'm planning on checking out some apartments while I'm in Houston. That's on my to-do list. All right, I'm gonna sign off for now because I'm like overstimulated right now, and I need a break. Uh, Especially because I started thinking about all these different classes I'm trying to do, and just started thinking about calendars, and I overloaded myself, so I need a break. Um, all right, I'm gonna send you over to Aussie Redirect. Um, I'm gonna send you over that way, and I'll talk to you later. All right, bye for now.